You are watching PR English Shorthand Dictations YouTube channel.
This is English shorthand dictation number 341 and the dictation speed is 120 words per minute. Ready? Start. We have heard the counsel on both sides. The facts are that the respondents were engaged on daily wages on muster roll basis in central scheme and were paid out of the funds provided by the central government. It is stated that after the scheme was closed, their services were dispensed with. When the respondents filed the writ petition in the High Court gave interim direction dated 6th January 1993 and directed them to be re engaged elsewhere. Pursuant to the interim direction, the writ petition came to be disposed of on March 9, 1993. Thus, this appeal is by special leave. It is seen that when the project is completed and closed due to non availability of funds, consequently, the employees have to go along with the closed project. The High Court was not right in giving the direction to regularize them or to continue them in other places. No vested right is created in temporary employment. Directions cannot be given to regularize their services in the absence of any existing vacancies, nor directions be given to create posts by the state to a non existent establishment. The court would adopt pragmatic approach in giving directions. The directions would amount to creating of posts and continuing them in spite of non-availability of the work. We are of considered view that the directions issued by the High Court are absolutely illegal, warranting our interference. The order of the High Court is set aside. The appeal is allowed. We have heard learned counsel for the parties. The short question which arises for consideration is whether the High Court was right in coming to the conclusion that a plot of land which had been allotted to the appellant could not have been converted to a residential plot on which construction could be made in as much as it was meant to be an open space. The proceedings before the High Court were initiated on a writ petition being filed by the respondent as a public interest litigation, inter alia contending that the respondent had purchased a plot of land on the understanding that the plot in question in the present appeal was really an open space adjoining a kindergarten school. The respondent found in 1995 that the appellant was constructing a house and thereupon a writ petition was filed in the High Court, which issued notice and on 8th of March 1995 granted stay of further construction. The High Court ultimately allowed the writ petition and came to the conclusion that, in as much as the plot in question was earmarked as an open area adjoining a school, it could not have been converted into a residential plot without following an appropriate procedure. On behalf of the appellant, our attention has been drawn to a notification dated 15th February 1941, whereby development plan of the area in question was approved. It is not in dispute that, as per this notification, in the development plan, the plot in question purchased by the appellant was shown as a residential plot. Of course, this area had earlier been earmarked as an open space, but by virtue of the development plan now approved on 15th February 1991, the change of user had occurred. The respondent in the writ petition filed in the High Court had not challenged this notification of 15th February 1991. The High Court, in turn, also did not quash this notification. There being no challenge to this notification, the development plan, which was so approved, became final. The land use which was shown in the development plan not having been challenged, we fail to appreciate as to how the High Court could have ignored this fact and come to a contrary conclusion. The appellant had purchased this plot of land in April 1991 and had admittedly started construction in January 1995. The writ petition was filed nearly 4 years after the approval of the development plan wide notification dated 15th February 1991, and apart from the questions of laches, even on merits, there was no reason for the High Court to have interfered when the residential plot shown in the duly approved development plan had been allotted as a residential plot to the appellant and was used for constructing a residential unit therein, merely because at an earlier point of time when the respondent had constructed his house, this plot had been shown as an open space cannot give a right to the respondent to ask the High Court to prevent the construction on that area when the respondent has chosen not to challenge the change in the land use from open space to residential as per the approved plan. On this ground alone, in our opinion, the writ petition filed by the respondent should have been dismissed. For the aforesaid reasons, the appeal is allowed. The judgment of the High Court is set aside and the writ petition filed by the respondent is dismissed. However, there will be no order as to costs. The appellant was appointed as Sub-Inspector Food and Supplies by respondent number 2 on 13/4/1975 on ad hoc basis against serviceman quota. The post was purely temporary, liable to be terminated without notice and without assigning any reasons or on arrival of a regular candidate. The appellant continued in service on that post till November 17, 1980, when his services were terminated. Prior to the termination of his services, he was placed under suspension on April 15, 1980, in view of the criminal proceedings under Section 420 of Indian Penal Code pending against him, and before the culmination of criminal proceedings, his services were terminated by order dated November 17, 1980, as aforesaid. Criminal case against the appellant was decided on October 21, 1981, wherein he was acquitted of the charge. The appellant, on receiving the order of termination of his services, filed civil suit 453 of 1981 in the court of senior sub judge, praying for a declaration that the orders of suspension as also termination were illegal, wrong, arbitrary, and without jurisdiction, and that the appellant was entitled to reinstatement and regularization of his service under the government notification dated 1/1/1980, issued by the Chief Secretary to the Government of Haryana, authorizing regularization of such ad hoc employees who held the Class 3 posts for a minimum period of 2 years. According to the appellant, his case was covered by the said notification, and as such, he was entitled to all the benefits of service. The senior sub judge held that as the appellant was acquitted of the offense, the authorities should have revoked the suspension order and should have paid the pay for the period for which the appellant remained under suspension, and thus allowed to the appellant all the benefits. An appeal was taken by the respondents to the additional district judge, who affirmed the order of the trial court, holding that no inquiry was conducted before termination of service of the appellant.